It just shows this misguided idea that there is some adversarial approach to proving the ATO got it wrong.
You might expect that the ATO will do that first. They won't.
The important thing to remember is there is nothing that says there must be a document that substantiates that. Hi, I'm Nigel Evans and I'm joined by Michael Buscema. We're both from Aptum Legal. Today we're going to be talking about some of the strategic considerations for taxpayers when they take their tax disputes to the Administrative Review Tribunal. I'm curious, you've got an enormous amount of experience in watching both the Commissioner and taxpayers go through this tribunal experience. Tell me some of the key insights.
When making that application to the tribunal, the most important thing they need to consider is that as soon as they take that step, from that point onwards, the burden is on them to prove their case. They can no longer try to give information to help someone else come to a decision in isolation. They need to consider, well, the ATO has said this, I disagree, but what do I say it is? And do I have the records and information available to prove what I say it is? Because as soon as that application commences, that taxpayer is going to be responsible for putting those facts, putting those positions to the tribunal in a relatively short period of time. And you might expect that the ATO will do that first. They won't. It is on the taxpayer. So you need to be prepared to have your arguments set out in terms of what I need to prove my taxable position, what information and evidence do I have to prove that, and where are my gaps in evidence, and what can I do to fill those gaps so that I can help the tribunal member come to a decision in my favour.
The critical point you've made about the switch when you get to the tribunal of that burden and emphasis on being, for the taxpayer to be proactive, it's a different experience in the tribunal because, as you've pointed out, there is an interactive experience at audit and objection level where the ATO is more engaged in prompting you and requesting certain information. So you've got a greater interactive experience. You don't get that at the tribunal. It's not like you're sitting in a room with the tribunal member and interacting about, well, and the tribunal member's coming back to you saying, well, I think you should provide this and you should do that. You're left alone, so to speak, and the Commissioner will, more often than not, leave you alone and will do nothing more than just poke holes in the way in which you present that information. So your point about suddenly things change and it's all on you to make sure you are presenting a clear, coherent, cogent material to demonstrate your taxable position. You have to do that in a way where you don't get that same level of interaction. And so one of the things I observed, and consistently observed, was this idea that the taxpayer thought that what they were there to do was to prove that the ATO got it wrong. I was just always stunned at the number of times taxpayers would get bogged down in the idea that this grievance about the ATO's conduct, to the point where taxpayers are, I'm going to call this particular ATO officer to give evidence. I mean, you would have seen that so many times. And it's laughable in the sense that it's obviously not relevant, but it just shows this misguided idea that there is some adversarial approach to proving the ATO got it wrong.
And it's a very emotional response. It's understandable if you've been in a dispute for a number of years. Yeah. But you're right, I saw it in almost all tribunal matters. And one of the biggest difficulties in letting it go, and the way I like to get clients to think about it is to think about the tribunal as an opportunity to put forward your case to a different person. Yeah. You almost have to pretend that the Commissioner is not involved. And I think, though, it is important to remember that you are, to an extent, in control of what that process could look like. Given that there's different people at the ATO, you can be as responsive to that tribunal process or as independent as you want to. You might have good reason to just work on it yourself, gather your evidence, put your strongest case forward, and limit the ability for the ATO to poke holes in your argument. But there is a lot of scope, given how long tribunal processes can go, for you to do that exact same task, but approach the Commissioner and say, hey, up to this point, you've had these questions. These are my answers to those questions that haven't been given previously. Here's the additional information. There is scope to utilise the new personnel in the ATO looking at your matter to perhaps generate an outcome, but they're usually not going to push for that themselves because they don't need to. It is your application, and that is the biggest difference when you get to a tribunal process.
That identifies for me something that I consistently observed as a barrister when I was acting primarily for the Commissioner. Quite often the review application in the tribunal is the first time the taxpayer is taking that process seriously. Quite often it's at the tribunal stage precisely because the taxpayer has not considered what the burden requires of them, has not taken seriously the obligation to make sure that they're presenting the information to the Commissioner, to the ATO, through the audit and objection stages to convince the ATO, to persuade the ATO, to ensure that the ATO has enough material to make the appropriate decision. It's obviously not too late, is one message when you get to the tribunal. If you haven't done it through the audit and objection stage for whatever reason, one of the beauties of the review application at the tribunal is you get to do it all from the scratch. So you haven't lost the opportunity to do it, but equally, if you did it before, if you did it well at the audit stage, you're probably not going to find yourself in the tribunal. We've spoken a lot about the burden, and we've spoken a lot about the taxpayer's obligation to make sure they're presenting the evidence and materials, if we're at the tribunal stage, to the tribunal, but prior to that to the Commissioner. What are we talking about here? What do you need to produce to establish a taxable position?
The first thing I think about when a client makes an application is proving what your case is. So it's usually identifying the transaction or transactions that are said to have occurred or not occurred, thinking about, okay, well, in those transactions, what do I need to prove? I need to prove that the expense or the income was derived or incurred. How do I prove that? What documents do I have? Once I do that, I then need to explain how that's linked to sort of the income producing part of the business, etc. Prove the nexus, which is usually a combination of documentary evidence and explanation. Once you have that framework, you can identify what all the supporting material you need to prove your claim, so that you can ask yourself a question. Do I have a gap in the records that I have to directly prove the matters I'm trying to raise? Or do I have those records, but I need other evidence to be able to contextualize those records to help convince the decision maker of their veracity? And there's a difference between the two. But you need to be able to identify that at the start and acquire those records. Given the ATO can look back a fair period of time, particularly if they've done an evasion finding, you often have imperfect records, which is where the contextualization part becomes very important. Because a useful thing to consider is, yes, you have the burden of proving what your taxable position is, but that burden is on the balance of probabilities. So you don't need to prove beyond reasonable doubt every cent of income you earned. You do need to prove it, but to a degree, which means there are opportunities to supplement contemporaneous records. So contemporaneous records are primary. They are the most important records, and you need to acquire all of them that you can to prove what your case theory is. And it's only once you've exhausted that you can look to the supplementary evidence. But I'm curious from your perspective, particularly when dealing with witnesses, where those witnesses are also the applicants, some of the hurdles or complications arise when people, particularly trying to put forward their own statements as to what happened.
There is a bias from the Commissioner's perspective that says, well, if I don't see what are the primary supporting documents, then it must follow that you cannot substantiate your position. And we've both seen that time and time again. And there's some understanding in that position because, again, we're starting back from that foundational principle that the ATO doesn't know anything about your taxable position, doesn't know anything about your transactions or your business. And the important thing to remember is there is nothing that says there must be a document that substantiates that. You can, for example, go into the witness box in the tribunal and you can give evidence or have others give evidence, and that evidence can be sufficient to fill the gap that the documents do not. And together with contemporaneous materials, those primary documents, and the evidence, it is possible then for the tribunal to say, well, I'm satisfied on the balance of probabilities that this is your taxable position. So you have to have a clear sense of what it is you're trying to establish. You have to understand the steps in the chain to establish that. You have to identify all of the available materials, because as we know, the possibility of convincing the tribunal in the absence of any records is going to be extremely difficult. And then you have to identify what those gaps are, and can those gaps be filled with someone giving evidence to explain in a way that is believable. What would you say, or what strategies do you recommend to taxpayers to ensure they still might be able to get a good outcome on penalty?
It's always important to recognise, firstly, that penalty is its own issue. A taxpayer's feeling is that they're right on the core part, so they're being penalised for something that they thought was true. That's not strictly how the penalty regime applies. So what you need to do is look at the penalty you got, because the penalty you get can be different. It can be a penalty based on the behaviour that the HO says you had in lodging your return at the time you lodged the return, and the level of that behaviour. Or it could be a penalty because they say that you had no reasonably arguable position. Once you determine the type of penalty, then that opens up consideration of what you can then argue from a behavioural perspective that is completely different to your primary case. You can say, I should win on the primary case and the tax should fall away, and to the extent there's no tax, there's no penalty. Alternatively, if I lose on those points, then I should be entitled to a lower penalty, because irrespective of the primary case, there are circumstances that contextualise my behaviour in a way that should make a tribunal find that my behaviour wasn't as either intentional or reckless as the HO has said. Alternatively, if it was, there are some personal considerations that should come into it that should remit that penalty. So penalties is actually one of the very few options where you can put forward an argument around your personal circumstances. A lot of taxpayers like to do it, but it doesn't really work often in the primary setting. But that's your opportunity when you're talking about penalty, because you can really bring in everything else that was happening at that time to mitigate the behaviour, and you can often succeed simply on the penalty issue, even if you lose the primary matter.
Yeah, so there seems to me a couple of issues here. The first is ensure that when you're at the tribunal stage, you are thinking about penalty as a discrete issue. That's number one. And number two, there are two key factors involved in addressing the penalty issue that are different from the underlying liability issue. And they are the conduct that led to you making the statements you did, and the circumstances that might suggest it's appropriate to remit that penalty. So there's those two factors. I wonder if you can talk through an example of the kind of evidence you might lead to change, for example, a penalty from recklessness to a lack of reasonable care, the 50% to 25%.
Often the ATO can intertwine their finding on a tax position with what they assume the behaviour is, assuming that an individual knows tax well enough that they understand the consequences of what has been reported, or they understand the tax regime well enough that they ought to have known that what they reported was wrong. So in my experience, evidence that has helped lower that is being able to demonstrate that the taxpayer's knowledge or understanding, based on either their education, their personal circumstances, or their advice that they proactively got from specialist advisors, made it reasonable for them to not have been grossly indifferent as to what their obligations are, but their behaviour was actually at a much lower standard than that, is around contextualising that they haven't either gone out of their way to avoid their tax, that they haven't closed their eyes to the tax consequences, that within the context of what that taxpayer's like, if they've got no formal education background, English as a second language, for example, that is all relevant to the intent of the taxpayer in making those statements, and therefore relevant to bringing the penalty down.
Yeah, so from an evidence perspective, we're separating two things here. we've talked about the evidence you need to substantiate the taxable position, and that's going to be the evidence about the underlying transactions, the underlying income and deductions, and what you put forward as your taxable position. The penalty evidence is about the steps that you took when reporting that information. And so it involves a different lens and a different inquiry. And I think it's important that the taxpayer appreciates that I have to lead evidence about the underlying transactions, but when I'm attacking a penalty question on the basis that I might lose on the liability issue, it's important I'm leading evidence about, well, what did I do to make sure I got this right?
And it's often forgotten, but on the same token, when you do it, it is often, not always, but often evidence that's very difficult to prove otherwise because they're entirely personal circumstances.
Yes.
I think one of the significant advantages of the tribunal stage is that compared to the earlier stages in the dispute process, the tribunal stage is sometimes the first time that the ATO actively turns their mind to the risk that their position that they've taken to date gets put in the public domain. And that comes with the risk of them losing on a technical point or losing on a reputational issue. Now, that by itself might be enough to pull them in so that you can have a conversation to settle. But also, because it increases their risks, they then bring in even more areas. And when that happens and they've split up all the decision-making functions, you can actually leverage that to push for various, say, alternative dispute resolution processes to give the ATO an out and then try to get through a settlement. Particularly if you've gone through a protracted audit and even objection where there's been limited opportunity to sit in a room with the decision maker and explain your case, given they need to confront that risk at a tribunal that things are going to go in the public domain, you can use that and use your ability to present your case proactively to bring relevant decision makers who are fresh to the dispute into a room, whether it's a conciliation with the tribunal or a conference, or even one of the ATO's internal ones like a facilitation, to be able to have those discussions to more meaningfully progress the dispute and resolve it. That is often very difficult to get when you're part of just a bigger number of disputes at audit and objection.
Now, this is a terrific insight because it goes back to this idea that you've got a fresh perspective at each stage and a particularly fresh perspective when it comes to the tribunal stage. I love this idea that the nature of the risks change for the commissioner in a way that introduces new people into the decision-making process. I think it would be helpful to understand the context behind the way in which the commissioner approaches settlement and this idea that litigation risk at a tribunal stage can become more important. Perhaps you can just talk through the kind of decision-making process that is going on at the ATO when you're at that tribunal stage and the way in which you might be able to leverage that in order to resolve this dispute without having to go all the way through to decision stage.
I think the best way to answer that is to explain the shift that happens between the audit and the tribunal. At audit, they're concerned with the tax risk and they're concerned with allowing the taxpayer to get the benefit of something that they wouldn't want other taxpayers to get and have viewed your arrangement with that lens. However, when you get to the tribunal, that risk gets viewed somewhat differently because you might still have the same underlying risk as the ATO, as the revenue authority, but the risk is heightened on the negative side because if it gets pushed all the way to a hearing and the ATO loses, then not only did they lose that case, that could have precedential consequences for a bunch of other audits at the other stage. And that broadness of risk decision making is probably more noticeable at a tribunal stage. So it is about presenting your case in a way that either differentiates your profile from the risk profile that was the reason you were audited in the first place, or sufficiently demonstrating the evidence to show that you will be able to prove that the ATO's interpretation doesn't apply in your circumstances. The ATO is not going to want an adverse decision, particularly if they're wanting to show a sign to the community that they don't tolerate this behaviour. And it's within that context that it can be much easier to bring the ATO to the table to settle, but you need to put in that work to understand the drivers of how you got to that dispute and what you can do to be able to prove your case to the point where the ATO won't want to push it all the way to a hearing.